Hi, everyone. Good afternoon. We're just going to give it a couple more minutes so people can join and get settled in. Hope everyone's doing well today. All right. Got a few more people coming in. If you can keep your mic muted during this webinar, that would be really helpful. And hi, everyone. I'm Helen French, Director of Development and Continuing Education at NASW New Jersey. Really happy to see you today and to see some familiar faces and some old friends. When you signed up for this community conversation, you agreed to a code of conduct, and we expect you to respect the other participants and the presenters, and I know you will because you're professionals. This community conversation is brought to us by our friends at ASI, and we are really happy to have the dream team again to talk about defining and communicating boundaries in your relationships with clients. So Lonnie, I think you were going to go.
Yes, and I want to thank everybody for allowing us to present and share some information. Our conversation today, this is definitely a chapter community conversation here for you. So what we'll try to do is, share some initial content and encourage you to definitely either ask questions live or through the chat. And we're going to talk today about boundary issues. And that's a pretty wide term, and we're anxious to talk about that today. I'm Lonnie Ropp. I'm Vice President of Underwriting and Distribution. And basically, I work with the NASW Risk Retention Group, which is 100% our liability program for our professionals in the organization. I wanted to introduce the other folks today, and we'll start with Phil, and then Phil will go ahead and introduce Dina. So,
yeah, hi, I'm Phil Lawson. I'm Vice President of Risk and Product Development at ASI Risk Retention Group. And Dina?
Hi, I'm Dina Larson. Some of you may have visited with me if you've called the NASW Risk Retention Group hotline. You would have heard, I'm Dina Larson. I'm a senior risk analyst from GB Healthcare, formerly known as Western Litigation, if my voice sounds familiar. And thank you so much for having us here today.
And Dina, if you want to, jump right in and share some of our high-level observations in the area of boundary issues that we encounter here and there.
Absolutely. So this conversation is a kind of a continuation of last week when we were talking about sexual misconduct, and that basic claim happens because boundaries have not been established and held. You have to do both parts. Boundaries are important things to set, and you got to set them in stone. They've got to be absolutely solid, and you have to stick with them. Some common examples that we see, whether it is in board complaints or regular complaints or suits or anything like that, common things that we see are money loans. Perhaps a client wants to loan you money, or you want to loan a client money because they're down on their luck a little bit. They need a little to get them through till the next payday, whatever. No. It's a boundary cross. Don't do it. Living arrangements, however well intended, please don't take a client under your roof. Additionally, please don't move in with a client. That doesn't end well either. And we'll get into some specific details on those. Buying things for clients or accepting gifts from clients. That you don't want to do that either. Again, that's crossing that professional boundary. Please just hold tight with that. Hosting clients socially. If you're having a backyard barbecue, it's not a good idea to invite the clients over. It's crossing the line. Social media connections are the trickiest because, and I know we're live streaming this on Facebook, but you need to be extremely careful. If you set up, for example, if you set up a profile for your business on Facebook and you post some things and people comment or you comment on other people's pages, stop to think before you do that, because you think you're clicking on one person's page, but that person has friends. Those friends have friends, and so on and so on. It's like throwing the rock in the pond and the ripples just keep going out. You never know who's going to see that comment or be affected by that comment, and it can end very badly. So please be careful with social media. Very, very careful. The best tips that we can give you is to avoid these things as best you can. In order to avoid that, you need to set your boundaries with your client up front. One of your first conversations with your client needs to establish those boundaries. Boundaries concerning electronic communication. If you will accept text messaging, how detailed is that text messaging? Is it only for cancellation or confirming appointments? Or do you do more than that? Set the boundary. If you've got an hours, I will answer text messages between 9 and 5, not after. Set the boundary, okay? Have a list of referral options available. So if you've got a client you're working with and all of a sudden maybe the issue of recreational drug use comes up and that's not in your wheelhouse, you don't want to give advice in an area that you're not experienced at. Have some resources available for the client so that you don't have to cross a boundary. Or if you have a shared personal circumstance, I guess you've both experienced the same thing, car accident, something. And rather than share in detail what you went through, maybe you need to refer that person somewhere else to talk about that so that your paths don't get too intermeshed. When community conflicts arise, and this happens a lot in small towns. I was born and raised in a small town. I knew when I was a teenager, if I got in trouble, my mom and dad would hear about it before I got home, right? It's the nature of small towns. It's going to happen. It can even be that you attend the same church. That happens. Have a conversation with the client up front about how you're going to handle that. That therapy's off the books. You are at that on Sunday, you attend the same church. That's it. No therapy, no nothing. You're just two people who happen to attend the same church. Same thing. Social media connections, we talked about. You set very, very clear boundaries about that. You will not accept friends. You will not accept them as a friend. You won't comment on their friends. You won't share their TikTok videos or their Instagram pictures, whatever it is. Set the boundaries. You want to be transparent if a topic comes up that there is a possible boundary cross. You want to talk about it with the client, and then please document it very, very clearly in your chart. This is not the time to be vague. This is the time for detail. What did you share with the client? What was their response? What was your ultimate resolution of the potential conflict? Because if you don't write it down now, you're not going to remember the details in a month. It's important. Phil, anything that I missed or we need to jump in on, or any
Yeah,
additional?
I can back it up to the high level for you all. Last week we talked about sexual misconduct, and I had a lot of cases and examples, and every one of them is rooted in a boundary violation. It's just a matter of how significant they become. A couple things I want to go over with you. You have a clinical role with the social worker or the therapist, whoever's providing the professional services, and because of that clinical setting, they're held to a higher standard than normal. And for example, you could have something called a curbside counsel, where if you just happen to have a friend, you get out of a taxi cab and you see somebody an acquaintance on the sidewalk, and they tell you about a certain situation they're having, and it's a friend, and you just say, okay, well, try this or that or the other thing. That may not be a boundary violation because it's not a client, it was just a friend, it was just a suggestion. On the other hand, if it happened to be a client or a past client, you make that suggestion, that becomes maybe a professional service. So you've crossed that, that boundary. But what we're saying here is that it all starts with boundary rules that have to be established at the onset of the clinical role. So what's that mean is set up your guardrails and your firewalls on day one with the client. And the clinical role states define that differently. So you really need to, wherever you're practicing, you really need to understand the state statutes. Because what I noticed is in my research for this is it's very fuzzy. There's a number of definitions that I came up with for you that we've circulated, and there's a lot of qualitative subjectivity to those. And they talk about quote unquote inappropriate contact or communication. Well, what does that mean? Everybody has a different definition of that. Maybe crossing verbal, physical, or emotional or social lines. Again, that could be ambiguous. So you have to look at the statutes, and then when you look at the statutes, even there in the state statutes, even they sometimes are not objectively crisp. They could be pliable and fuzzy, and that's where you get into a gray area, and that's when you have plaintiffs' counsel and defendants' counsel argue before the court, and then they make decisions on that, which is not the black letter law. It's interpreting the statute subjectively. That becomes common law court decisions, not predicates, but court cases that have been decided through litigation. So really, it depends on your clinical role, and look to the culturally accepted norms and mores of the states and the statutes that cover that, because they'll probably vary by state. But picture a continuum. It starts at a pliable, fuzzy, subjective area of what it really means to cross a boundary or what those boundaries are, versus an objectively crisp rule. And when you start your practice with, or your therapy with a particular client, it's good to get that documented, lay the ground rules out, so there's not a chance for a qualitative or subjective interpretation. Now that's pretty much what I had to contribute here.
Yeah, just tag in behind Bill. Setting the boundaries, and I'm fond of paper. I'm a paralegal by profession, and so my life has been spent dealing with litigated matters and courts and everything. And paper is proof. And so if you've got, as part of your intake documentation, a list of what your boundaries are, it's easy to go back and remind a client, don't forget, we talked about this. Remember, here's the paper from the front. You signed it. See, remember? And so then as the therapy session, or as the therapy relationship is continuing and growing, you can go back and remind the client that, remember, we talked about this. And if they choose to forget, which happens. I've got licensing board complaints on my desk right now where clients have misinterpreted or chosen to push the boundaries or broken through the boundaries, but they blame the social worker for that issue. You can go back and you can say, well, we went over all of this. These are my boundaries. These are my rules. These are the rules I have for everybody. Everybody applies, you know, the same rules apply to all my clients. You want that. You want to have consistency.
Yeah,
So you can back it up. It's important.
there may be court precedents. That's the word I was looking for, where you have the black letter law and the statutes that tell you what you have to do, and then that varies by state. But then you also have precedents at trial court that you can use as a defense, or the plaintiff might use as an offense against you. Something else I wanted to mention, it popped out of my mind. I'll turn it back over to you, Dean, and then.
Okay, I'll start with my section of horror stories. The unfortunate part of my horror stories is that these are true. These are actual claims that have come across my desk. I've been working with NASW Risk Retention Group now for about 9 years, and there are very few claims that I have not seen. Let's talk about the money loans. I've seen quite a few licensing board complaints that are filed not necessarily by the client who received or gave the money, but in that case, it's usually a family member who makes the claim that the social worker is taking advantage of their elderly mother and getting money from them. Living arrangements. I'm thinking of one right now where a social worker for health issues moved in with a client to have someone that could assist with some of their health issues. And a licensing board complaint was filed by the client's neighbor because they said the social worker was committing insurance fraud for billing improperly and also stealing money from the client because they were living in the house. Stealing money, stealing food, stealing everything. True or not, the social worker now has to deal with that and has the potential of a hit against their license. Could be continuing ed credits, could be suspension. We don't know. It all depends on what the board finds. Hosting clients socially. I think that's an easy one to you want to be careful with that. Again, taking it in context with one of the other possibilities. If you're all members of the same church group or bridge club or something, you need to be extremely careful if you are the host. Social media connections. I'm sorry, go ahead.
Yeah. Hey, there's a question in the chat, and it sort of kind of correlates to what you're just talking about. So if you don't mind me interrupting, I was going to share it. What are your thoughts about having a small talk conversation if you see a client in a social setting?
That absolutely, that is one. If you can address that at the beginning of therapy and say, okay, we live in a small town, odds are pretty good I'm going to see you walking past in Walmart. I may just say hi. I may not acknowledge you. It's not personal. You and the client decide how best to handle that situation. Is it going to be a hi and move on? You have to take into consideration that people in your community know what you do for a living. And it is possible if they see you talking with a client that they're going to assume that that person is your client, whether they are or not. So you need to think through the possibilities, have that discussion with the client, and, just say if there's something that's come up and, you see the person in passing, they want to say, hey, I need to have an extra session this week. You can do a real quick, go ahead and send me an email. I'll get you on the schedule and move on real quick, real quiet, because the rest of Walmart doesn't need to hear your discussion. But if you can address that up front so that the boundaries can stay in place.
Yeah, Dina, you mentioned, this is a thing that I forgot to mention previously. You said send an email. There's, and you talk about setting with boundary rules, you're setting firewalls and guardrails. That brings in the issue of how you communicate and how you document and how you take notes. And everything you write down, every teletherapy you have could be recorded, could be heard by a third party. Emails that you send, any communication like that, whether it's written or digital, that becomes property that is part of the case, part of the therapy. And that then becomes subject to the HIPAA high-tech law. That's a federal law that Congress passed in, I think it was 2012, and it was enacted in 2013. And there's some really stiff penalties on therapists who allow third-party breach. Okay, I want to distinguish between that. A third party is somebody who, a scammer who gets into your computer and looks at all your documentation, or maybe it's a mover who moved your paper files and they were breached. If there's any kind of records breach, that's by a third party, that falls under the HIPAA high-tech law, and there's lots of penalties and things that you have to do to rectify that. One example is you have to notify everybody in your practice that there was a breach, not just the one person that the notes were breached about. And several other things. Now, there is an insurance policy that we sell that's pretty inexpensive. It's a cyber, and for members, that's, I think it's $59 a year. It's really cheap. But there's another thing. It's called first party breach, and a first party is you, the social worker. The second party is the patient. And so we have a professional liability policy that covers first party breach. So a lot of policies don't have that, competitors' policies, and we do. So in other words, if a burglar breaks into your office, even opens a file and closes it and doesn't take anything out, which has been a claim in the past, we pay for that. We handle that. So, you know, so I want to make that distinction. There's a sublimit on it, but we still handle that.
Mhm. I actually have another really good question, if you guys are ready.
Sure.
And this is sort of kind of back to the beginning. I'm just gonna, it's an observation, but I'm gonna share it in question form, about the issue of giving and receiving gifts, need to take into account cultural issues and specifics of the relationship and issues. Would we need to do a thorough assessment in different situations, and how would you position that?
Okay. Cultural issues obviously need to be handled delicately, because heaven forbid that you offend anyone, especially someone who's coming to you for help. You don't want to offend them. You don't want to, you know, seem that your refusal of a gift is anything more than just, I'm trying to hold boundaries here. This is where conversation comes in. You need to have the conversation with the client. And I keep thinking of my very dear friend Diane, who is Jewish, and gifts that she has exchanged with me. And I think about that in a practice setting. If there is something that someone gives you because they think it would be, you know, it would be look nice in your office, or something that they think you could use, like some of those fidget things or something, anything, you just have to be very, very careful. If you stop and think about it, switch the giver givee from you and your client to you and your primary care physician. Do you give gifts to your primary care physician? No, you don't. Do you accept gifts from your primary care physician? Other than probably free samples, which I always take because medications are expensive. No, you don't get gifts from your primary care physician. So you just need to be careful, have the conversation, learn as much as you can about that, the cultural thing that may be creating the gift circumstance, and then just address it as best you can.
Yeah, that's something I wanted to add is the, I have a note on that. Depends on the clinical role, but what are we talking about here? Culturally accepted norms and mores reconciled with what the state statutes are. So what's a more? Well, characteristics or conventions or maybe customs of that community. Well, that's really a slippery, fuzzy definition as well. It's pliable, it's subjective. So my recommendation would be first go, what are the precedents that have been set in the state courts, and what's the black letter law in the state on that? And more times than not, you'll find that that's probably crossing a boundary where you're exchanging gifts like that. It's and that's only my opinion, what I've seen, but that's your first step in in a boundary crossing. Now, if that's in a clinical relationship, that's not the same as if you're that's professional services. That's not the same as if you're a co-employee or something like that. That's a little different, so that'd be my advice.
I actually have another question. Dina, did you want to follow up with that? I have another question when you guys are ready.
Okay, hang on to that, Lonnie. And I know the question that's going to be created from this because I can hear it coming. And the answer is, I don't know when the question comes up. And that is, you need to also consider the monetary value of the gift.
Mm.
If you have an elderly client and they start giving you like very valuable pieces of china or something, please don't take it. Please kindly give it back, because what you're opening yourself up to is a claim from a family member saying that you're rooking grandma out of her their inheritance.
Yeah, property.
If it's, I brought you some nice flowers from my garden because they cheer up your office. Okay, yeah, maybe that would be all right one time. Don't make it a habit. But if it's something that's got a lot of value, sentimental value, family value,
what that falls into is boundary violations that refer to a potentially unethical act or acts, and it would be harmful for the therapeutic relationship within that professional service.
yeah.
And it could be harmful. It could be deemed harmful for the client and exploitation for personal gain. So that's an example.
Yeah.
Where where that could hurt you too.
Mm-hmm.
Okay, you had the question.
So, and I'm catching up, but I'm not all the way to the bottom yet. So I apologize if some of these questions may have been answered by colleagues. But I think that this is actually pretty important. When seeing a client for the first time, is the first thing we discuss the consent agreement as opposed to what they are coming in for. And I'm just going to elaborate my perception on this is that if I'm going in for, specific needs, I mean, really honestly, the consent agreement could potentially take up the whole session. And if I showed up, the average consumer not understanding that risk management effort needs to take place in some form, I could walk away being dissatisfied and have issues as well. So how would you handle that? I think that's a very good question and very important.
That is a really good question. I would say, I think you need to at least get a baseline idea of why the client is coming in, because that conversation can dictate if you can continue to treat that client. So, and this is my standard example, because these people are not everybody has this skill set or this training, but if somebody's coming in for drug and alcohol issues, that's a pretty specialized practice, and you don't want to be giving out advice or treating people unless you really know what you're doing. And so if somebody comes into you and says, I need to talk to somebody, I've got issues with alcohol and recreational marijuana use and all that stuff, there's no point in going through the consent agreement when you're going to refer them to one of your colleagues that is experienced at that. So I would say get a basic idea. You don't have to get down in, down into the nitty gritty on the first meeting. Hear what they had to say, and then you say, okay, thank you very much for that. I appreciate that. I've made some notes. I know what kind of things, where I'm going to go from here, but we need to have an initial conversation about our work together.
Does a practitioner always
Work with you.
Does a practitioner always do that in person, or do they qualify on the phone first?
I think it's individual to each therapist. There are some who pre-qualify on the phone. There are some who do it in person. Sometimes it's telehealth. I don't think that it's wrong in any of those circumstances. But then you do want to have that conversation and explain to them, this is how I work, and this is how you and I are going to work together. And then explain the boundaries and the rules of the house, as I call them. This is how my practice works. This is what we're going to do. I don't answer text messages. I'll send you a text to confirm an appointment. You respond back and say yes, and that's it. I do know that there are therapists out there who work with adolescents, teenagers, and they feel very strongly that sometimes the only way they can reach that teen is by text messaging, because that's what we're raising a country of people who are not going to have usable thumbs from doing texting. I understand that, but I'm cautious about that, just because of the issues that can come up around texting.
Yeah, third party breach.
Third party breach. The biggest one in my mind is, do you know for sure who's on the other end of that phone?
Yeah.
Do you know for sure who has that phone in their hand? And you could wind up very quickly. I thought about this last night as I was going through my notes for this. If you've got a teen, you think you're talking to your teen client, and they start sending messages of a questionable nature, we'll be polite today because it's Tuesday. And then they start sending pictures that are inappropriate. You are hip deep in boundary crossing right there. You're looking at a sexual misconduct claim filed by somebody. If you don't get your arms around that quick, it's a slippery slope. So just please be careful with it.
And I believe I may have, and I apologize if I might have missed anything, but if I have, please, restate your question. But I think I've exhausted the chat questions. Would anybody like to perhaps, and Helen, it's your call on how it walks forward, but ask a question in person.
Yeah, if you've got a question you'd like to ask in person, please raise your yellow hand.
I did see a quick comment flash up about that consent needs to be in writing, and thank you, Ruth, for pointing that out. My personal belief, because I think this holds up better, is that the consent conversation needs to be both in writing and verbal. The in writing needs to be, as you stated, in a language or an education level that can be understood by your client. But it's also important to go over that document with your client so that any questions that they have can be answered.
And that's why I put that in there too, right? That informed consent, at least, I mean, in Illinois, it's in our law. I don't know about New Jersey, right? That you have to have a conversation. You have to be open to questions. You have to help know that they understand it. That's what I was just posting here, right? That informed consent is part of empowerment and self-determination for us as social workers. It's setting the boundaries, but it's also part of our values.
Well, it is, and it also kind of lets the client know where they stand as well. So I tend to believe it's rather empowering for the client as well, because then they know how to work with you. They know how to ask questions. They know how to disagree with you. They know you're putting a very firm shape around your relationship with them, They may be coming to you with issues that are absolutely out of their control. But by you sitting, having this conversation with them and setting the boundaries and saying, this is how our relationship looks, that's giving them a teeny bit of control back in their life. They can control this relationship. They can control what goes on between the two of you. It's
When you're
big thing.
when you're setting the ground rules initially, that's ethical.
Yes.
Boundary violations refer to unethical acts that are harmful to the therapeutic relationship. And so the earlier, from day one, when you set those boundaries in an ethical manner, you're showing, at least you're showing the court, if it eventually becomes a litigated matter for some reason, at least you go back to day one and show what you did that was ethical. And you stayed bound to that through the series of therapy meetings.
I've spoken with a lot of social workers lately. I swear the longer this COVID business goes on, the crazier people are getting. And I use that term with all love and affection. But I talk to a lot of social workers who are dealing with, they are treating a child who is caught between divorcing parents. Those never end well. Those are always very, very tough conversations to have, because the therapist, you guys are trying to help this child, and the parents are coming at you from both directions, wanting, they want this, they want that. They're texting, they're emailing, they're calling, they're burning up your voicemail. They're doing all sorts of things. I talk to a lot of social workers who say, what can I do? That's what I tell them. You go back to basics. You go back to the beginning. You get both parents on the phone or in the room or on a chat or on telehealth, whatever you need to do. And I always prefer if you have both parents hearing the message at the same time, just because then that way nobody can say, well, you told him, but you didn't tell me, or whatever. But you sit down and you remind them, these are the rules of the house. This is how we're going to behave. If you can't do this, we need to come up with a better plan for you and your child. Because
you better be really careful there. I've been running claims and risks for the RG since we founded it in 2012. And that's a serious claim. It's relatively frequent, very severe, to the point where most of our competitors, actually, I haven't found a competitor that will cover divorce litigation. Some of them offer an endorsement, but it's very strict. It has very low sublimits, which means you don't have much coverage for legal defense or damages. And there's many steps that you have to go through. I won't get into the technicalities of it, but it involves legal steps with a third-party counsel to make sure you're covered under that endorsement for that specific treatment of couples going through divorce, because then you get into child issues as well. First thing I'd recommend, if you're getting involved with any kind of divorce litigation, check your insurance policy. And if you have one with us, with the RG, you're covered. But if you have one with somebody else, you're probably not covered. And if you do have an endorsement, you're probably not fully covered anyway with that other carrier.
What we see are most oftentimes board complaints, and those are filed by one parent or the other. And usually there's a claim of boundary issues. You didn't respect my boundary, or you let him in, but you didn't let me in, saying that I have boundaries, but the other parent doesn't, that kind of thing. And those are the times, again, where your documentation is going to be so important, because it shows what you did, the boundaries that you set up front with your clients, and that you're holding all parties to the same boundaries.
Yeah, that issue no longer becomes boundary, becomes how much dirt I can get on my spouse.
That's exactly.
And the social worker's caught in the middle there.
Yeah, that's exactly what's going on. One parent is trying to get dirt on the other. If I've talked to any of you on the hotline and you've had this question for me, we've had this conversation, that it is no longer about the child. It is not about what's best for the child. It's, I want to win, but I want you to lose even more. And what dirt can I get on my former spouse so that I can come out better? And at the bottom, at the very bottom of it, and I've been a paralegal for 30 plus years, at the bottom of this is always money. Who's going to get more child support? Who doesn't have to pay more child support? It's unfortunately not about the child, but that's when you have the opportunity to go back with those parents and say, we're going back to the beginning. Do you recall this piece of paper that both of you signed? Which is why I'm a big fan of signing pages, because the signature is powerful. It means something. And if you can, if you can hold up a piece of paper that the parent signed when they're saying, I never saw that, you didn't read that to me. Well, look at the bottom, here's your signature. Yeah, you did. We went over this, you signed it. It's a lot easier to hold them to a certain behavior if you've set the boundaries and made them promise to abide by them. Again, by something as simple as a signature.
We have another question. Can a consent sent via text be adequate until a written one can be signed? And the individual suggesting that they're thinking specifically about getting consent to speak to somebody that the client wants them to speak to, but they haven't signed an official release yet. So wanted to see if that was a good choice.
I would say yes with qualifications. Yes, I think it's fine. I would make sure that you have had a conversation with the client, a verbal conversation, because again, you don't know who's holding that phone. You don't know who's got that phone in their hand when they say, oh yes, please talk to my husband's attorney and tell him everything. Could be the husband, could be the husband's girlfriend. We don't know.
If it was me, I'd probably talk to my lawyer about that, on what channels of communication to use. How it could come back and bite me on that.
Save the text. You want to save the text to the file. You want to document in the file that you received a text. And as soon as humanly possible, get a signed document from that client and get it in the chart.
Yeah, the reason I mentioned that is I don't know what every state law or statute, they could vary. Some of them may not accept texts or emails as contract. I don't know. It depends on what the state statutes say. That's why I said an attorney might help you guide through that.
I have another question when you guys are ready.
Sure.
What if one parent is willing to give consent for their child to participate in therapy, but refuses to participate in the treatment? So most of the work is with the parent who is willing to participate. So that sort of kind of brings up
That's another legal question I wouldn't want to answer.
Oh, that's unfortunately, though, Phil, that's a question I answer on the hotline on a weekly basis.
You're confident.
Great question. So thank you so much, everybody, for asking them. When you are dealing with consent issues, my preference is that you get consent from both parents. If the parents are divorced or are in the process of getting a divorce, do yourself a big favor and get a copy of whatever custody order is currently in place. If a parent says, well, I don't have, mom calls, she wants to get her kid in, and she says, well, I don't have a copy of the custody order, but it's fine. You can go ahead and treat. That's a big red flag. They're hiding something. Tell them that you need the custody order before you can begin.
Is that for every state, Dina? Every state has a custody order requirement?
I don't know that it's a requirement, Phil. I think it's a good risk management tip. Because if you've got the custody order, it is quite possible that there is language in that order telling you who can consent to treat.
But so that's why I'm saying you might be, if I was a social worker and I was dealt with this, I'd want to talk to my lawyer to find out what the state law is with respect to custody orders and what what kind of movement I can do to treat a situation like that.
Well, a lot of it, Phil, is going to depend on the language in the order. Each judge is probably going to write things a little different.
Well, I'm going beyond what the judge says. I'm going to see what the statute says, you know?
Yeah, that may be something that you'd want to talk to an attorney about. I don't know that.
Yeah.
I don't know that there is a specific statute that says this must always be in a custody.
No,
order.
none of us would know that. None of us, and only the attorneys that practice in that venue would know that. They wouldn't know all 50 states either.
And so I think to get back to Lonnie's question, you've got consent from, if I'm understanding right, Lonnie, and correct me on this, you've got consent from both parents, but then all of a sudden one parent says consent, but then they don't want to participate. They agree to let you treat, but that's all they want to do. Am I hearing that?
I'm going to read the question again, just for purposes, because it wasn't my question, just in general. So what if one parent is willing to give consent for their child to participate in therapy, but refuses to participate in the treatment? So most of the work is with the parent who is willing to participate.
Okay. That's a choice by that parent. If you've got consent to treat, you can treat. If you've got a parent who chooses not to participate, you have to decide how to work around that parent. Does that parent, and maybe talk to that parent and say, okay, you're choosing not to participate. Do you want to have monthly updates of how your child is doing? How much information do you want? Or do you just want to sign things when I need something signed? Have a conversation, find out what they want, and then document it.
Mm-hmm.
Documenting it.
And Phil, one question is, can you state again the name of the liability insurance plan? And Elizabeth, it looks as though you might have had another part of that question. So if you did, certainly.
Well, what I was referring to was the NASW professional liability policy. It's a risk retention group. We cover claims that arise from divorce litigation. To my knowledge, no other carrier does. There is one carrier, and I forget who it is, that will cover part of it, but you have to buy an endorsement. And before they even allow you to do that, you have to have counsel meet with both parents and go through a whole lot of hoops and checklists of things that they have to do, so the carrier is comfortable granting that endorsement. So that's a real headache, and it costs money because the legal fees are paid by the insured, not by the insurance company, even to get that endorsement. So, I mean, I'm not trying to, this isn't a commercial for our policy, but I'm just telling you, it's a fact of life that nobody has the comprehensive coverage that we provide at no cost with a zero deductible for divorce litigation. We do that because we're affiliated with the NASW.
Lonnie, I have some other questions popping up. Are you?
Yep, I'm getting ready to. Yes, thank you, Dana. One question is, if you're doing teletherapy, how do you get a signature? Send it through the mail. And if we do this, how can we be sure that the person is signing the person when you need it from? So do management programs address that? As a child study team member, there was a form that parents would fill out and check a box if they agree. Would that be acceptable?
Okay, let's take that in pieces. So Lonnie, you may have to
let's do the first question first.
How do you do teletherapy and get the consent signed? Absolutely, you do it through the mail.
Okay.
Document that you had the conversation, that the person does consent. I know some social workers send their documentation out in advance. Maybe you've got a web page where you can download your documentation. This is actually a pretty common question, especially since everybody got tossed to teletherapy without a whole lot of choice in the matter. So get consent, get verbal consent while you're on the face-to-face chat with the client, or the telehealth chat with the client, and then have them sign it and mail it back to you so you have a signature in there. It's just a good thing to do.
Mhm.
Okay, what was the next?
And then is if we do this, how can we be sure that the person signing is the person you need it from? So like, you know, if somebody signed on somebody else's behalf.
If someone signed on someone else's behalf, I would ask for documentation supporting that they are allowed to sign. For example, if you have someone
Guardianship,
power of attorney,
their guardianship, yeah.
guardianship, get a copy of the guardianship papers, get a copy of the power of attorney. If they are court appointed guardians, get a copy of whatever legal documents you have. You need something to back it up.
Yeah.
Absolutely.
Yeah, and I believe that this may have been answered below, Helen, so forgive me. But one question is, do management programs address this? And right below that, there is a reference to a platform where there is an option, I believe, that pertained to that. I think just to carry it through as a child study team member, there was a form parents would fill out and check a box if they agree. And would this be acceptable? My thought is
Uh,
no.
I mean, if they check the box and then sign it at the bottom, I need a signature.
Yeah.
Feel better with a signature.
Let me look below. I think I have a few more questions. Email addresses, as we come to a close, sure. We'll go ahead and include that. And the email forms to clients prior having them. Okay, I'm just catching up. What if you use DocuSign? That's a choice.
That is a choice. That is something that a lot of law firms use. I got a DocuSign document yesterday. I believe it allows things to be transmitted securely. If the client agrees to sign through DocuSign, and as many things go with your practice, the client has to agree to do it. If you've got somebody, and I think of my dear sweet father when I say this, if you've got somebody who's not comfortable with electronic stuff and they want to see you in person and they want to have paper in their hands and they want to sign the papers, then that's what you do. If you've got younger people who are in this day and age, it's all electronics. That's all they want to do. If they can't do it on their phone, it doesn't count. You handle that appropriately. I think you have to deal with each client individually as far as DocuSign, but again, just make sure that the client has agreed to proceed with that. I had a question, interestingly, last Friday from someone asking about taking credit card payments and the security of it. And part of the conversation that we had was, does your client agree to have their information transmitted to the credit card company so that the payment can be processed? Not that I'm sure the credit card company cares what you pay or what you're using your card for. But that's personal information that's going from you to the credit card company back to the client so they can pay the bill. It's personal. Make sure the client agrees. Conversation, it's a big thing. It's not just sit at your desk and check boxes and say, okay, we talked about this, we talked about this, we talked about this, let's go. Have a conversation. Let the client ask questions so you can get those boundaries firmly in place, bedrock, rock solid, deep, and then hold them. Okay. Helen, I think we've got about 5 minutes, and I know these wonderful people have things that they need to do. So anything else we need to cover here?
Very thorough.
Well, if any other questions come up after, like I'm usually the one that 5 minutes after I hang up the phone, I remember one thing I wanted to ask. So please, if you have questions afterwards, shoot them to Helen. If Lonnie put email addresses in the chat, whatever we need, we'll do the best we can to get an answer back to you.
Mhm. And there's actually 2 email addresses in my response. Go ahead and do both email addresses because it ensures expediency. So that's most helpful in that regard. Mhm.
Brilliant. Okay.
Also, a lot of
yeah.
questions can be answered, sorry, Helen, by going to NASWassurance.org. NASW Assurance Services, it has information about all the programs, but professional liability and risk management tips and some helpful information, not only related to this topic, but many others are also there as well. So NASWassurance.org.
Helen just threw that at that website in the chat. So thank you, Helen.
My pleasure. Oh my goodness, I really followed along with this one. There's some really concrete answers that you gave, and we often get these questions. So everybody who registered also got a fact sheet, which was very good of you to supply. Thank you so much. And you've got emails if you've got further questions, or send to me and I will forward to the group. You are amazing. Go off and be insurance giants, Phil, Lonnie, and Dina, and everybody who joined us today. Thank you so much for your time, and we will see you at the next community conversation. Bye, everyone.
Bye-bye.